afternoon, and welcome to your Construction Safety Association of Manitoba's 2025 virtual webinar series. My name is Megan Story, and I am the Training and Development Manager of the Construction Safety Association of Manitoba, and we are proud to be recognized as your premier and trusted source for safety and health information, resources, training, and core certification. Today's virtual webinar is an example of how we are striving to provide you with practical and relevant information to help with accident prevention in your workplace. For those of you who know CSAM, quite simply, our answer is yes. How can we help? We will have the answers to your safety questions, or we will find an answer with the help of our qualified resources and partners in safety and health. Today, I am pleased to introduce Jennifer Sokal and Curtis Unfried. In today's webinar, we will dive deep into the critical aspects of due diligence in workplace safety and explore the legal framework surrounding due diligence defenses in serious workplace incidents and OHS charges, specifically focusing on Manitoba regulations. Please note that this webinar is being recorded, and a copy of Jennifer and Curtis's presentation will be made available. Also, please note that questions will be answered at the end of the session today. So as you have questions that come up, please feel free to add them to the chat on your screen below. Without further ado, I'd like to pass this over to Jennifer and Curtis. The screen is all yours.
Great. Thank you for that introduction. As indicated, my name is Curtis Unfried. I'm a partner with MLT Aikins here in Winnipeg, and I'm joined by my colleague and associate Jennifer Sokal. I've been practicing in this area of workplace safety and health, or occupational safety and health, for the past 25 years. Obviously, for those of you who have been in the industry for that long or even longer, I'm sure you'd agree with me that there's been a significant impetus to improve upon workplace safety and health legislation and the steps taken to protect workers from harm as far as reasonably practicable. So today's presentation is Your Friend Due Diligence, Keeping Your Workers Safe and Avoiding Workplace Safety and Health Act Charges. As Megan indicated, our primary focus is going to be on Manitoba. If you do happen to have business outside of this jurisdiction, we could obviously help you as well. I should add that our firm is the only firm in Canada that has offices in all 4 Western provinces. So we've got quite a very, very good bench strength when it comes to dealing with this type of issue in those 4 provinces. We also practice in Ontario as well. And we'll obviously do what you can to assist you in dealing with defense to any charges or in dealing with the investigation. As the agenda sets out here, we will touch on the legal framework and principles. We'll also talk about the game plan, which is managing the serious incident investigation and to avoid common errors. We'll obviously provide you with some practical examples from real life incidents that have occurred and which we've been involved in. And obviously, we'll end with the possible outcomes that may result when a serious incident occurs. We do have a lot to cover, so without further ado, I'll turn it over to Jen at this point. As indicated as well, the jurisdictional issues, we will focus on Manitoba, but if you're outside of the jurisdiction or are federally regulated, there will be other laws that are applicable to you, but given time constraints, again will be focusing on Manitoba. So without further ado, Jennifer Sokal.
Hi, everyone. I will be discussing the legal framework and principles surrounding the due diligence defense. That will set us up well for discussing, what practical things you can do to, first of all, keep your workers safe. But if, the worst happens and someone does get hurt, how to make sure that you're managing that incident investigation well in order to protect your company. So a charge under the Workplace Safety and Health Act is a strict liability offense. And so if you are charged with a strict liability offense, they do not need to prove that you intended to do it. So for instance, in the criminal realm, if you were charged with murder, they have to prove that you intended to do it, that you had the mens rea to do it. The other side of the coin there is, if you have a driving infraction, they don't need to prove that you intended it or, whether there's a reason for it. It's just, did you do it or did you not? Strict liability is somewhere in the middle of that. And so once the act is proven, and so essentially, if you, using the examples here, if you did not ensure that regular inspections of the workplace were conducted, if you did not ensure, as far as reasonably practicable, the safety, health, and welfare at work of all your workers, that's the act. So once that's proven that that was done, the burden shifts to you as the employer to prove on a balance of probabilities, so 51%, that you took all reasonable steps in the circumstances, and that's due diligence. Did you or did you not perform your due diligence to prevent that act from occurring? So due diligence means taking care. And the Supreme Court has a leading case on this where they say, as I mentioned, it's not up to the prosecution to prove negligence. It's really up to you as the employer to prove that you took all due care. Oftentimes when we're fighting with the Crown prosecutor or arguing that with the Crown prosecutor, we're arguing about whether they're trying to hold an employer to a standard of perfection. That's often the key issue in the case is, did you take all reasonable care, or are they asking for something more than that? Again, as I mentioned, you have to take all reasonable steps to avoid the particular event. So all reasonable steps will be, establishing a proper system to ensure that these types of incidents, safety incidents, don't occur, that these risks aren't, remaining in the workplace. And it's also by taking reasonable steps to ensure that that system that you've put in place is effectively operating. And so what we've put here is what that actually means. You have to be able to prove that you were aware of your statutory duties and your obligations, that you had assessed the risks and the hazards in the workplace, that you'd carried out those duties. So PPE, training, supervision, your JHAs and your SWPs, and that you'd actually maintain standards of quality with respect to those duties. So sometimes we see, for instance, employers will have SWPs in place that no one actually follows, or, the employer might be aware that a guard has been removed from a piece of equipment. That's not employing your obligations because you're aware that, even though you have the system in place, it's not being utilized. Another key here thing, and Kurt's going to get into more of the practical, advice, but another key thing here is discipline. If you're aware that your employees are, not following your safety rules, you should be disciplining them for that. If they got injured or someone got injured because of their non-compliance with the safety rule, and Workplace Safety and Health finds out that everyone knew that they weren't following this rule, it's almost as if the rule wasn't there, right? So in order to discharge your duty to, take all due care, you have to make sure that you're actually enforcing your rules. Another key thing there too, I should say, is maintenance, performing regular inspections of equipment and things like that. So when you're thinking about your workplace and what, if you've thought of all the hazards that might be there and all of the, SWPs that you should be creating and having and the training that you should be doing, these are the types of questions that you should be asking yourself. What's the standard of care common in the industry? Is the level of risk, so high that you should be taking even more care than you might take in a usual circumstance? Are there alternatives available to the way that you do things? Systems that you can buy, programs that you can license, things like that. Is there extra training that you can do? Refresher training, things like that. So the Supreme Court has said that to prove that you took due diligence, you have to, they focus on control. And so if you're controlling the hazards, this can be done by supervision, inspection, improving business methods, and, exerting your influence over your employees to make sure that they're following the rules. You're not required to anticipate every possible failure, but you are required to take all reasonable steps to prevent a foreseeable, injury or event, which I'll get into in a moment. Foreseeability, though, is a complex issue, and so I'll get into that now. So one case here, Thomas Fuller and Sons, this was a case where workers were laying concrete piping to make a makeshift winch system. They did not consult an engineer when they were making this winch system. They were relying on manufacturer instructions and industry standards, and they designed and constructed a metal brace. That brace snapped, and it ended up killing a worker when it snapped. At first, the company was acquitted, but then a retrial was actually ordered to determine if the company had failed to ensure that every part of the project was designed and constructed to support and resist all loads that it was likely to be subjected to. The court said that you don't need to take each and every precaution that would be reasonable to take. The real question, it's that second one in this block here, the real question is whether you took all the care that a reasonable person might have been expected to take in the circumstances. The court acquitted the company, and they said that it was reasonable for them to have looked at industry standards and the manufacturer's instructions, and that just because they hadn't consulted an engineer, which arguably was available to them, they hadn't failed to take all due care. A reasonable person would not have needed to consult an engineer in the circumstances. So being generally due diligent is not enough. You really do need to look at each part of, your workplace, your systems, different steps and things that you take in your day-to-day work to determine if it's reasonable that a specific contravention could occur or a specific type of injury could occur. And foreseeability merely means determining the risks in advance. There are some charges or some, risks that are so foreseeable that they're in the act. Those are those ones that talk about asbestos, falling from heights, pinch points, things like that. Essentially, if there is a requirement in the regulations that says you must do this, the court's going to find that that risk was foreseeable. It's really when the Crown is laying a charge that says that, you failed to, keep your worker as safe as reasonably practicable, which they lay in every offense. That's when we're looking at, outside of those specific steps that you have to take that are written in the regulations, was there more that you should have done? And so the last bullet here is helpful. It's, there's a distinction between the foreseeability of a hazard and how the risk can manifest. So you don't need to know exactly how, a freak accident might occur. It can be enough to foresee the risk of, that injury happening. So here we're talking about a serviceman getting run over by a truck. That's foreseeable, even if the way he was run over by the truck was, like I said, a freak accident. You need to have foreseen that getting run over by a truck is a risk, and need to have taken steps and ensured that you have safe work procedures and trained your workers on that and supervise your workers and making sure that they're actually following those rules to avoid them getting run over by a truck. So here's another case that talks about foreseeability a bit. A worker was removing equipment at a foundry when he was seriously injured when a large section of ductwork fell on him. The company was convicted of the general duty that I just talked about there for failing to ensure the safety of their workers. And the Crown essentially said, by not ensuring that the ductwork was adequately supported while being dismantled, you did not keep your workers as safe as reasonably practicable. And the company argued that this was not a foreseeable risk. The court found that the collapse was by a buildup of sand in the ductwork that could not have been expected, and it wasn't reasonable for the company to have to expect every inch of that ductwork. And so in this case, the court found that it was not a foreseeable risk and the company was acquitted. Also, when you're thinking about the standards, when we're looking at the regs, like I said, if it's in the regs, it's a foreseeable risk. You have to do what the regs say. Keep in mind that, updates do happen to the regs every now and then. They have not happened since 2019. I would imagine there might be some coming up shortly, but thinking about, the old guards might not be enough. What you need to do for asbestos might not be enough if you're complying with the regulations as they once were and not how they are now. You need to keep on top of things. So as I mentioned, be proactive on safety. Make sure that you have training generally. You have the knowledge of the rules, training and supervision, and discipline. And making sure that you have an active safety and health committee is key. One thing that we see a lot of our clients doing is making sure that they have a culture of reporting. So if there is any type of safety issue that comes up in the day, workers are told, over and over again, immediately contact your supervisor, immediately let him or her know about the safety concerns so that it can be addressed. Make sure that you go through the manufacturer specs for your pieces of equipment. That is one thing we'll see often is where there'll be a way that a piece of equipment's been used for years and years and years. It's been generally safe. No one's been hurt. Something happens, a longtime employee gets hurt, the company gets charged, and we look at the manufacturer specs, and there was a blatant violation of one of the rules in the specs. So make sure that you're familiar with those. They're dense, but it's worth the read to make sure that you're keeping your workers safe. Refresher training is also huge. The rule of thumb is usually every 3 years. But making sure, if there's a near miss, maybe you do want to do the refresher training on an earlier basis. Refresher training should be also given to your supervisors on the, train the trainer and supervisor obligations and things like that. But also a training, make sure that it's documented. From the workplace safety and health perspective, if it's not documented, it didn't happen. So you're spending all this money and time to make sure that your workers are safe. You want to take the extra effort to make sure it's properly documented. And there's some great consultants in this sphere that can provide you with software that makes that really easy. Or if you're a smaller outfit, you can also do it the old-fashioned way with pen and paper, and making sure that that's saved in your system. I jumped ahead because I already mentioned supervisors quite a bit, but supervisors are key to making sure that your safety program is safe and working properly. You shouldn't be promoting a supervisor just because they've been a loyal worker for a long time. You actually need to be able to think, can this person enforce the standards that they're required to enforce? Can they, discipline their peers that, were their peers for such a long time? Can they actually enforce your standards? Are they organized? Again, with the documentation, it's the most important thing in establishing that you have taken due diligence. And, they could be doing the training and not documenting it properly. So make sure that they have that. And supervising your supervisors and, doing performance reviews of your supervisors can help you to make sure that they're doing things the way they're supposed to do. Again, discipline is important. You have to make sure that you're documenting discipline, and even verbal warnings should be documented on a file. So sometimes that's confusing to people because of the fact that a verbal warning is verbal, not written, but the difference is, a written warning is given to a worker in a written format. A verbal warning will be given to the worker in a verbal format, but you might still document it, and you should still document it in your system that you've given that warning. If the safety violations are severe enough and are, consistent enough, termination might be an option. I'm sure many of you are familiar with progressive discipline. So you should be balancing your obligations from an HR legal perspective with your obligations from a safety perspective. And now I will pass back to Kurt.
Great. Thank you for that, Jen. It's also important to be proactive when it comes to third-party contractors. I wanted to touch on the Supreme Court of Canada decision of Ontario and the city of Sudbury. This was rendered in 2023. And this is a situation where you have two sophisticated entities in the form of of the city of Sudbury and Interpaving, which was a longstanding company that was very experienced in road construction. The city put out a tender for bids. Interpaving, who had worked with them in the past, was the successful bidder. They started working on the project, and one of the terms in the agreement that they entered into stated that the city was relying upon and basically, and that Interpaving was contracting to be responsible for compliance with all regulations relating to occupational health and safety. Very common. I'm sure many of you out there have similar terms in your agreements. And what ended up happening is an elderly woman who was walking in the area was struck by a road grader that was performing repairs, and she was killed. Unfortunately, there was no signaler that was assisting the grader operator, nor was there a fence erected between the public way and the work site, which resulted in her, getting in the way of this particular piece of machinery. The regulation stated that such a signaler and such a fence was required. Eventually, both were prosecuted under the act, proceeded to trial, and it made its way all the way up to the Supreme Court of Canada. I should add as well that initially the city was acquitted at trial, but then the Crown appealed. There was a finding of guilt imposed then. It went to the Supreme Court of Canada, and in a 4-4 split, which meant that the Court of Appeal decision still applied, they ruled that the owner, in this case, the city of Sudbury, which was defined as an employer under Ontario's legislation, even when they were not the employer of the person involved in the safety incident and did not have direct control, they could still be held liable. And for lawyers such as myself and Jen, this was a head scratcher and caused a great deal of panic because many agreements had been drafted that allowed for entities such as the city to basically contract with third parties such as Interpaving to make them responsible for this. And what this decision said was it's not that simple. There could be liability on the city as well. And if there's a failure by the owner or to diligently create safety programs or safety systems, that liability would follow. Next slide, please. The matter was sent back to court for a decision as to whether or not there was due diligence exercised by the city and whether or not they met the obligations. And thankfully, the city was acquitted. The judge did find, when it was sent back, he did find that there was sufficient evidence in place to be acquitted and to show due diligence. And they were found that they delegated the authority to Interpaving, but they also took reasonable steps to ensure that Interpaving was complying with the regulations, and that they had inspectors that would show up every few days to monitor the work that was being done to be sure that they were following what was required. They also led evidence showing that they pre-qualified the contractors that bid on the project. And for those of you, again, that are in that aspect of contracting, it's important to ensure that you're dealing with proper and competent contractors when you are contracting with them. Don't be dealing with some fly-by-night operators. You might have somebody that has never properly done a job before, even though you have a term in the contract that may delegate their responsibility to ensure that they're the ones responsible for workplace safety and health. That might not be enough. So be sure that you get competent, qualified people involved, and also be sure that you take some reasonable steps to ensure that they are complying. Again, you don't need to be there 24/7 to watch every single thing that they're doing, but it's important to show up every once in a while to be sure that there's nothing obvious. Next, with respect to the game plan and managing serious incidents, this is obviously a key for anybody involved. We can advise that from a practical perspective, we've dealt with many situations where people have panicked in the immediate aftermath of a serious incident. That's why we recommend that you have a documented game plan, so that if or when a serious incident occurs, you've got a piece of paper to refer to walk you through what needs to be done. Train your supervisors on the game plan to be sure that they know what to do when or if the incident occurs. One of the things that we highlight during these types of presentations is to ensure that the injured worker is transported where it's appropriate. We had a case a few years ago where an employee was injured. Their arm was caught in a piece of machinery. It was fractured in a few places, and after first aid was rendered to him, this worker drove himself to the hospital. Not surprisingly, workplace safety and health did not like that, and they actually laid additional charges due to the fact that this employee should not have been driving himself to the hospital. There was all sorts of things that could have gone wrong. There could have been shock, could have kicked in. There could have been all sorts of things. So we recommend that people ensure that that's covered off in the game plan. Have the worker transported by ambulance. That's generally what we recommend to ensure that the proper care is provided. If that's not an option, then ensure that he's transported by somebody else driving the vehicle, and even if that worker may be asking to do so him or herself. Also preserve the incident scene. This is another common thing that does not occur when people are not following a game plan. You've got an obligation once the worker has been removed from the scene and first aid has been provided. You basically should be putting up some tape around the area so that nobody messes with the scene, so that the investigation be conducted by both workplace safety and health and by your own safety committee. We could advise that in the past we've had workers that have tried to be helpful. They've gone in and cleaned up the blood from the scene prior to workplace safety and health arriving. They've moved equipment, put it back to where it was prior to the incident. All that stuff, although they thought they were being helpful, actually harmed the company, in that disturbing the incident scene can be additional charges under the act. As well, you must report the incident immediately and by the fastest means of communication available. A failure to do this is a charge in of itself. And we could advise that based on the case law that there have been 7 employers that have been convicted in Manitoba of failing to notify by way of the fastest means possible since 2017. So again, just be sure that that is properly documented. We'll be touching on the importance of the incident investigation report that is required, that has to be done when there is a serious incident a little bit later. But what you need to ensure is that when you are putting these investigation reports together, you include all relevant and positive information that you have in place to show the due diligence that was undertaken, so that even if there was a serious incident, that doesn't mean that you're necessarily guilty, because you can show that you had policies and procedures that should have prevented the incident from occurring. And again, that should be laid out in the incident investigation report. Most importantly, you also need to make changes to prevent the incident from occurring again. If there were shortcomings that were identified as a result of the incident investigation that was done afterwards, be sure that the improvements are done to address those shortcomings. We had a file recently where a worker was injured in the same way a few years prior. Basically, it was a piece of machinery that was involved. Incident a few years ago, it did not lead to any charges. Subsequent incident 2 years later, the exact same thing happened. Not surprisingly, workplace safety and health and the Crown Attorney's Office were able to use the prior incident as evidence of guilt to basically say, look, they clearly knew that this incident was reasonably foreseeable because the same thing happened 2 years ago. Although they may have done some refresher training, they didn't actually address the underlying issue. There should have been additional guarding that was put in place to address the shortcoming, and that didn't occur. So again, due diligence requires you to address things as they become known to you. So again, ensure that that's done under the circumstances. Workplace safety and health investigations. Again, whenever there's a serious incident, you're required to do this under legislation, and the investigations to determine what the underlying causes are and what steps should be taken to prevent a similar incident from occurring. The requirements of the investigation, which I'll touch on further a little bit later, are set out under Section 2.9 of the regulations. And of course, it's this information that will ultimately determine whether or not charges are laid under the Act. So again, be sure that the investigation is done properly. Do not rush it under any circumstances whatsoever. Do not panic. Again, this is the reason why we recommend having the documented game plan. You should also include in that game plan who the investigators are. Again, this should be your safety and health committee. that you have in place at the workplace. We also recommend creating an investigation charter, which kind of sets out the obligations of those involved with the committee. Generally ensuring that you've got one point person. You don't want to have too many people circulating the evidence or circulating the information around. Also ensure that you have appropriate oversight over those that are conducting the investigation. We have had incidents in the past where the person who has been put in charge wasn't necessarily aware of everything. They were relatively new hires, didn't know the relevant history, made a statement such as, saying that there was no safe workplace or covering specific procedure in place. And then when we got involved, we were able to determine that in fact there were safe work procedures in place that touched on the particular practice that was at issue. And if that person had not been corrected, and if there had not been that oversight, then there obviously would have been a very detrimental report created that would have been submitted to workplace safety and health. So again, if there is proper oversight, that shouldn't happen. We've also seen managers or workers commit various crimes after serious incident occurs. And again, this has been situations where people should have been doing something and weren't doing it. And then when, the proverbial shit hit the fan and the serious incident occurred, they were scrambling. In one instance, we had an individual create safety and health minutes years after the fact. This was due to the fact that there had been a meeting where a specific a specific safe work procedure had been discussed, and there had been employees there that were covering that were in attendance to review and cover that off. The guy didn't make any minutes of it, did not record the fact that the injured employee was there. Of course, when the incident occurred, right away is it's like, oh, well, yeah, I trained on that. And the safe work procedure was there. It covered this off, and that employee received training. Well, he didn't have proof by way of the minutes. He panicked after we met with him and miraculously came up with the minutes shortly thereafter. We were skeptical that these were legitimate and actually went into his computer system and were able to determine that the document in question had been created the day or two before. Thankfully, we caught it because this type of like backdating documents like that is a crime. There's a criminal code provision called uttering forged documents. And if you create a document falsely that you're going to use for other purposes, for people to rely upon it, you can be charged. So don't do that. Signature falsification was another one. Again, this had to do with training. Workers were supposed to sign off on receiving the training, and the supervisor was doing this in order to quote unquote save time. He was signing people's signatures for them. And not surprisingly, when the incident occurred, we met with the injured employee. He claimed that he did not receive the training. The supervisor said, no, 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 he did. Look, here's proof of it. And again, we see the document with the signature on it. We show that to the employee in question. He said, that is not my signature. I've never seen this document before. The worker came clean afterwards, and we were able to deal with it appropriately. But again, do not do this. We're providing you with some practical examples. And the reality is, if people had done their jobs properly, and if they had the proper oversight, they wouldn't have been in that situation. Next slide, please. Investigators are my friends, right? No, they're there to do a job, so be prepared. We highlight this because there are a lot of times when people work with safety and health investigators, it's a very cordial, positive relationship. You get the officer to show up and say, hey, guys, we want to work with you to ensure that this doesn't happen again. They might issue an improvement order, a stop work order. You work with them, you get the the stop work order or the improvement order lifted. You pat yourself on the back and think, great job. That's awesome. I'm really glad we were able to deal with this. And then wham, 2 years later, you get hit with a series of charges and you wonder what the heck happened. Well, again, they're there to do a job. And just because they're positive and cordial doesn't mean anything. You need to be alive to that fact. I also want to emphasize that there's no such thing as off the record. That several years ago, there was an incident where an officer had indicated that, basically, hey, can you tell me what really happened here, just off the record? And an employee said all sorts of things, some of which were true, some which were not. but it was extremely detrimental to the company, and we didn't find out about it until years later. Naturally, when we talked to the employee about it and asked him why he said that, he said, "Oh, I thought that was off the record." And of course, we told him it wasn't, and it was there in black and white in the report that was submitted as part of the part of the charges. So again, just avoid that, or be live to that issue. Um, don't be afraid to push back on improvement orders. Don't blindly agree to them. Again, you've spent the time, money, and resources to have workplace safety initiatives. Use them. This is where the due diligence kicks in. And just because one has been issued doesn't mean that it is right. Quite often we see people blindly agree to it and they just want to get workplace safety out the door and agree to whatever it is they say. Don't do it, because that could be used as evidence against you later on. If you still don't agree with the finding, or if you believe you have evidence or systems in place that address the issues identified in those orders, you can consider an appeal. It's a relatively straightforward issue that must, as long as it's filed within 14 days of the order being issued. Moreover, frame your response, even if again, there might be a disagreement with the officers. Still frame your response to show that you believe that you were already compliant. Again, this is due diligence defense, and that type of evidence could come in helpful later on down the road once it's reviewed by Crown attorneys or others at Workplace Safety and Health, so that you could hopefully avoid charges. Completing your report. These are the items under section 2.9 of the regulations that I touched on earlier. And I'll briefly touch on each of them. Obviously, sub A, the name of any person injured or killed. That's relatively straightforward. It's a simple matter of fact. Down to sub B, the date and time, again, straightforward. Sub C, a description of the incident. This should be a matter of fact. No assumptions should be made. Sub D, graphics, photographs, etc. This is where videos, witness statements, diagrams, safe work procedures, job hazard analysis, company policies, sorts of things are included. Discipline records is another one. Again, you want to include anything that's relevant that potentially touches on due diligence to show the steps that were taken by the company prior to the incident in question. Sub E is an explanation of the cause of the incident and the factors that directly or indirectly contributed to it. Again, the immediate cause is generally what actually happened to cause the incident. For example, a worker's hand coming into contact with a bandsaw. The indirect cause can be related to the task, worker, material, equipment, management, or environment. This requires a bit of a deeper analysis. For example, did the equipment malfunction because the worker failed to do the usual pre-visual inspection, or was there no policy for maintenance for that particular piece of equipment? Again, those are issues that will have to be considered on a case-by-case basis. But what we will highlight here is do not unnecessarily fall on your sword. You have the ability to frame the evidence here. And if you do have things that are helpful, be sure they're included. Any immediate corrective action that we're taking, this is sub F. Again, what have you done in the short term? Was there a reminder to workers to put in place a missing safe work procedure or to augment a safe work procedure? Did you discontinue use of equipment? Again, you could frame things here. For example, although we have a lockout tagout policy in place and workers are trained annually on this, workers were given refresher training on this policy. That's something that we often recommend be put in reports to illustrate that even though there may have been training done on this particular task a year or two beforehand, you're still proactive and again, doing refresher training on it, just to be sure, again, taking steps to ensure that it doesn't happen again. Lastly, any long-term action, again, this may require purchasing new equipment or installing new guards or otherwise, discussing solutions with manufacturers, etc. Even if you're dead in the water, and again, we've had this happen in the past where, for example, a guard was removed from a piece of equipment, should have been, which obviously shouldn't have occurred, and on its face, it doesn't look good. The employer is saying, look, we really screwed up here. We're dead in the water. Even if that may be the case, it's still important to show as part of the investigation what actually was in place. So yes, even though a guard may have been removed, the fact is you had a policy and procedure in place that should have prevented that from occurring. And if that was in fact the case, be sure that's included in the report as part of the investigation. Completing your report. Again, I've touched on the specifics already. Again, safe work procedures, job hazard analysis that were done. Again, a lot of times when workplace safety and health comes in, they have the benefit of hindsight and have 2020 vision, of course, in that regard. Well, if you've done a job hazard analysis on a particular piece of equipment and didn't identify the hazard that led to the injury, that isn't necessarily a bad thing. As long as you did conduct the job hazard analysis at one point, it's important to illustrate that and have that as part of the investigation to say, look, we had our committee look at this particular piece of equipment 2 years ago. The job hazard analysis created, we created a safe work procedure as a result of the JHA. Yes, we did miss what ultimately led to the injury, but that was not through lack of diligence on our part. And as you may be aware, should be aware, Jen touched on earlier, it's a standard of reasonableness, not one of perfection. So again, even though you may have missed it, still include the job hazard analysis as well. If you have dedicated safety staff, how often do you have safety meetings? What are the designations of those staff? Obviously, a lot of you are here today to further your knowledge. You might have a certificate of certification from various schools or other third-party entities. Include those. Do you have any audits that were done by third parties? Did you get a positive audit score on a particular area of the facility? That's all stuff that is illustrated, whether it's Safe Work Manitoba, other entities. Include that again, because it's relevant to the investigation to show what was done beforehand and also could be relevant after. And again, at the end of the day, for due diligence to show to workplace safety and health and to show others, Crown Attorney or otherwise, it's important to include all of that. Another thing is to try to avoid templates. This is another war story that we like to touch on, where they have these drop-down menus when you're dealing with investigation reports. What we found is that people are too reliant on that and they don't use their own language to cover it off. So they might use from the drop-down menu, for example, failure to adequately supervise. Again, it may not adequately address what actually happened, but that's the best thing that they add in the drop-down menu. So they use that. And we had this in one instance where they admitted that as part of the investigation, at least the initial draft, but it was evident that supervisors obviously cannot be there cannot be expected to have their eyes on their employees at all times. And this was a situation where the worker had done something on his own and that he was not told to do so by his supervisor and he had not been trained to do. He basically, again, did this on his own. Of course, if a supervisor had been there at the time to actually see it, he would have stopped it from happening. But that isn't, again, it should not have been the finding that was made, because the reality is the supervisor was there, he was in the area, he was in the vicinity. So there was actually a supervisor that was present, just not, again, at that exact moment. So we were able to eventually disclaim that finding as part of the report. Again, in that instance, it had actually been already submitted to Workplace Safety and Health, but we were able to have discussions with the Crown Attorney to illustrate that, in fact, even though that's what the report said, it really wasn't the case. We provided the additional evidence that should have been included as part of the initial draft that wasn't, and we were able to get the charges dropped. So again, be sure that that's included. Preparing witnesses. Workers are human. These interviews can be nerve-wracking, and it's important to prepare them so they ensure that they're comfortable and know what to expect. We generally provide a dry run on the types of questions that we can expect to ask. Again, we can't anticipate everything, but at least it helps the workers turn their minds to what to expect when the questions are asked, so that they aren't a deer in headlights. This includes showing workers their training documents, relevant policies and procedures, and other things to refresh their memories. Again, quite often when workers are not prepared, they'll show up, go into the interview room, expect to only be talking about the incident that occurred 2 or 3 days beforehand, which obviously is fresh in their mind. They get through that. And then the officer will ask, well, is there a safe work procedure for that policy, for that particular procedure? Were you trained on it? And if they do not, if they have not refreshed their memory and have not looked at the safe work procedures recently, they'll often forget about it. So again, it's key. Key is to be ensure that they're prepared. With that being said, you cannot tell your workers what to say or what not to say. The evidence is going to be the evidence. Don't tamper with them. Just prepare them. Possible outcomes when a serious incident occurs. This is the final portion of the presentation, and we'll stop for questions shortly thereafter. After the investigation has been conducted and you've submitted your report to OH, to Workplace Safety and Health, they will decide whether or not to refer the matter to the Crown Attorney for determine whether or not charges should be laid. The Crown has a two-step process. The first is to determine whether or not there's a reasonable likelihood of conviction. Again, that's basically, does the evidence support that something was done or not done, contrary to the regulations or the act. It's generally straightforward, and again, the evidence will be what it is. The second thing is a lot less certain in that it also must be in the public interest to prosecute. So this is where there is some discretion that's provided to the Crown Attorney's Office. And again, we've had situations where employers were dead in the water on liability. There's, again, for whatever reason, there was an incident that occurred and a worker was harmed because of it. And we've been able to provide evidence either in the form of the report or by way of a supplementary letter to illustrate that even though it occurred, there was a lot of due diligence in place. This was not a fly-by-night operator, that they had a safety procedure, a safe work procedure in place, that they had training, et cetera, et cetera. And what happens in those situations, in some instances at least, is the Crown Attorney will look at it and say, you know what, even though there may have been a violation here, there's a lot of positives, and I don't think it's in the public interest to prosecute because it's going to tie up our courts. And really, these aren't the types of guys that we should be going after. So again, it's important to have a thorough and proper report because of that discretion that may be available so that you avoid charges. Again, the fines now, when I first started in 1998, they were $15,000. Now they're up to $500,000 for a first offense and $1 million for a second. As far as recent fines, I should add for supervisors in Manitoba in July of 2022, a sole proprietor pled guilty after a worker fell 10 feet and broke his spine. There was a fine of $18,500 there. In 2019, there was an owner of Clarence's Automatic Transmissions and General Repairs. He pled guilty after a friend was helping him cut a steel drum in half. It exploded. There was a fire, and the friend was killed. He received a fine of $20,000. And there was also a supervisor by the name of Michael Noonan who pled guilty after he directed two workers to assist in repairing a commercial overhead door. It was weighing at approximately 300 pounds, and he received a fine of approximately $1,550 when the door fell to the ground and pinned a worker. So those were some recent cases that you should be aware of. The more serious one, potential outcome is criminal charges under the Criminal Code of Canada, and that's under Section 217 of the Criminal Code. And this is where senior officers can be charged, or supervisors. And this is it's everyone, and this is the specific provision. It's everyone who undertakes or has the authority to direct how another person does work, performs a task, is under a legal duty to take reasonable steps to prevent bodily harm. Again, this is the supervisor that's involved here. So be aware of it. The biggest case until recently was Metron Construction out of Ontario, where 4 workers died after falling from a swing stage in Toronto. This resulted in a 3.5-year sentence for one of Metron's project managers. I should add that the facts of those cases, if you're unaware of them, it was a situation where the workers were being rushed. There was a bonus under their contract that if they got the work done by January the 1st, there would be a bonus paid out. So these guys were working late December trying to get it done in advance of that deadline, and they did not properly tie off. And it resulted in this horrible tragedy. The foreman also died. I can tell you that there's little doubt he would have been charged as well if he had survived. So again, be sure that if you have the authority to direct, that you've you've taken reasonable steps to follow the procedures that are in place and in compliance with the Act. Most recently, just a few months ago in February of 2025, again, another decision from Ontario, an individual by the name of Milton Urgulis was sentenced to 5 years in prison after he failed to act. And in that situation, there was a light that came on in the truck indicating service. It was a service engine light soon. The driver told the supervisor about it, and he said, yeah, okay, we'll deal with it. He didn't deal with it. He didn't take the truck out of service. A week later, that same driver was out in the truck. The steering failed. He ended up in an accident and died. So again, that supervisor, what he should have done is when he became aware of this potential hazard, he should have taken that truck out of service and did not. And the court ultimately found him liable and sentenced him to 5 years. I can tell you that there has not been any criminal charges in Manitoba as of yet. There was a situation a few years ago involving Interlake asphalt paving. It was a very graphic situation where a 15-year-old boy was buried in hot asphalt at a work site. He was too young to be working at the work site and had received little training. Charges we thought were going to be laid there, criminal charges we thought were going to be laid there. Ultimately, the Crown did not. It's our understanding the only reason why that occurred is because the family did not want criminal charges. This was a family friend that had hired their son and was kind of doing it as a favor. And so they did not criminally charge, but did impose a fine of $33,500. I see Kristen knew the boy. It was indeed a very tragic situation. So with that said, that concludes our formal presentation, and we've got about 8 minutes. And we've got a few questions here. We got one from Adam. Do early project completion incentives expose employers to potential liability? The term itself should not. As long as, again, there can be incentives for contractors to get a job done, but they cannot do it by cutting corners on safety. So as long as they are compliant with the rules and regulations, there should not be any risk to attracting liability on that front. Another one from, is there an incident investigating charter or template, or is that a combination for policy practice and our procedures? Sorry, I should have elaborated on that. It's basically a document that's created at the time of the incident that governs how the evidence is collected, the one individual that the information should flow through. Like, again, this is generally the lead investigator, and as well the individuals that are there to assist him or her. It also confirms if there is a lawyer involved. It confirms that the evidence that is being shared for the purposes of seeking legal advice is in fact solicitor-client privilege and not subject to disclosure. So that's part of it. I don't know, Jen, if you want to add anything on that.
No, I don't want to add anything about the charter templates, but in terms of the investigation report templates itself, I know we spoke a bit about, not just following drop-down menus and things like that, but Safe Work Manitoba has a pretty good template for investigation reports, but if you're filling one out, don't be afraid to change it. If you need to change it to add in, more information about your company that puts you in a good light, if you need to add in, more, you need to change some of the options that are available, things like that. Like, don't be afraid to adapt it for your specific circumstance. The next question is, what is your definition of employer? So that's a legal question that depends on the jurisdiction that you're in. The case that Kurt talked about with the Supreme Court involving Sudbury, the Supreme Court interpreted Ontario's legislation as including the owner as an employer. That hasn't been tested the same way in Manitoba. So we don't have the exact answer for you. It would be subject to legal arguments in the case of, a situation where there's multiple companies involved with potentially controlling that worker.
I should say, Jen, it's just because it's relatively fresh in my mind, is that the the definition of employer, well, the one under Manitoba's Act, it's a person who employs one or more workers or contracts for the services they're under. But in Ontario, the definition included the contracting of third parties. So again, in that instance, Interpaving Limited, because the city of Sudbury contracted with Interpaving under Ontario's Act, the definition of employer was deemed to be included as part of that. So again, it depends on the jurisdiction that you're operating in, and Ontario's was more expansive than what most jurisdictions have. But again, that's something that you'll need to determine what jurisdiction you're operating in.
And we have a blog on our website, a few blogs actually, about that Sudbury case. If you search up mine or Kurt's name on the MLT Aikins website and you go to the blogs about Sudbury, we talk about that distinction and practical takeaways for companies trying to navigate the fact that there's been this interpretation in Ontario that should kind of govern how you conduct yourself, but also it hasn't been tested in Manitoba and in some of the other provinces.
Yeah, correct.
Any other questions? Oh, there might be two more here. Nope.
Yeah. Yes, it will be posted on YouTube channel. Okay. Yes, I'm glad. I don't know if there's any other questions, but yeah, we had a lot of information we wanted to convey to you, and it sounds like it was informative. So we want to thank you all for attending, and obviously, hopefully you'll never have to reach out to us in a legal context. But if you are unfortunately dealing with a serious incident, we're obviously here to help and help you navigate through things, because again, it's a very stressful situation whenever you go through these types of investigations. And Jen and I have we're up to over 30 years of combined experience on dealing with these types of things. So we're more than willing to help.
Well, thank you very much to both you and Jennifer for this great presentation this afternoon. Great feedback is already coming in on the chat. So thank you again. And thank you to all of you who have participated and joined us today. Much appreciated. Please go back to and check our YouTube channel in the next couple weeks. The recording of this presentation will be made available there, as well as you will receive an email from myself in the next little while with a copy of the slides from today's presentation. So thank you to everyone that participated today. We do appreciate your feedback. So I will be sending through in my email just a quick survey that if we ask that you complete. It helps us to make sure that we are keeping up to date with things that we're offering you. And if there's any other information that you would like to see us offer, we would be happy to offer that to you. Also, please watch this space, because we are going to have 3 more sessions coming up on webinars. In May, the first week of May is Safety and Health Week. And so we will be sure to have 3 sessions available for webinars at that time. So you can check us out on our website as well as on social media for more information. Otherwise, that's it from me. And thanks again. We will see you next time. Take care.